Hello everyone and welcome back to the channel. I'm Shoily Chakraborty working as a legal intern in LEXIS and Company. The topic of my video today is the landmark Shah Bano case. Mohammed Ahmed Khan versus Shah Bano Begum is a landmark lawsuit which has dealt with the problem of triple talaq verdict. This case is normally mentioned as the Shah Bano case. It is considered to be a very debatable and problematic legal contest in India. The case in Shah Bano struggled for rights against the injustice that was the triple talaq system. The facts of the case. In 1932, Shahbano was married to Muhammad Ahmed Khan, who was a renowned lawyer in Indore. They were the parents of three sons and two daughters, that is, total they had five children. After 14 years of marriage, Shahbano's husband married another young woman who was younger than him. In 1975, when Shahbano was 62 years old, she was disowned by her husband and was thrown out of her marital home along with her children. In April 1978, she brought an appeal under Section 125 of the Code of Criminal Procedure in the presence of Judicial Magistrate of Indore after when she was thrown away from her maternal home by her husband. Shahbano filed this suit in 1978 because her husband has abandoned her from the maintenance of rupees 200 a month which he guaranteed to give. A wife who is without an income and is neglected by her husband is entitled to maintenance, which includes a divorced wife who is not remarried. In November of 1978, he gave divorce to his wife Shahbano by articulating or uttering the triple talaq, and it was irrevocable. The argument or conflict between Shahbano's children and her husband's other wife were vital reasons or grounds on which divorce was relinquished and furnished. After he pronounced irrevocable triple talaq, he took a safeguard that since because of this divorce she is terminated to be her legal wife, due to which he was not accountable to furnish her with maintenance or alimony. The local court directed Muhammad Ahmed to furnish her rupees 25 per month to Shahbano in the form of maintenance. Shahbano in July of 1908, apart from this, made a plea to the High Court of Madhya Pradesh to alter the amount of maintenance to rupees 179 every month. Shahbano's president went to Supreme Court and filed a petition against the verdict of High Court of Madhya Pradesh. Her husband's essentially argument after divorce was that he cannot keep any form of alliance or connection with his divorced wife because it is not allowed by Islamic laws and it's haram, and hence he is not legally responsible to maintain his wife. Issues raised in the case: whether Section 125 of the Code of Criminal Procedure is connected with Muslims or not, whether the amount of meher given by the husband upon divorce is adequate to get the husband rid and is liable to maintain his wife or not, whether the Uniform Civil Code applies to all religions or not. The judgment. The verdict of the Shahbano case was conveyed by Chief Justice Chandrachud. All India Muslim Personal Law Board and Jamaat Ulema-e-Hind were the two Muslim bodies who accompanied the lawsuit as an intervener. On 3rd February 1981, Supreme Court gave a like-minded conclusion in this case and banished the plea of Muhammad Ahmed Khan and validated the verdict of High Court. The court held that Section 125 of Code of Criminal Procedure solicited to Muslims too, without any sort of discrimination. Supreme Court in this case held that since responsibility of Muslim husband towards her divorced wife is limited to the extent of iddat period, even though this situation does not contemplate the rule of law that is mentioned in Section 125 of the CRPC 1973. According to Supreme Court, this rule, according to Muslim law, was against humanity or was wrong because here a divorced wife was not in a condition to maintain herself. Thus, at the end, after a very long procedure, court finally concluded that the husband is legally liable will come to an end if divorced wife is competent enough to maintain herself. But this situation will be reversed in case when the wife is not able in a condition to finance or maintain herself after the iddat period. She will be entitled to receive maintenance or alimony under Section 125 of the CRPC. The Women Protection of Rights or Divorce Act of 1986. The judgment given in Chabano case was criticized among Muslims, and according to them, this decision was in conflict with the rules of the Quran and the Islamic laws. So, the Parliament of India in 1986 decided to enact the Muslim Women Protection of Rights of Divorce Act 1986. The main objective of this act was to protect the rights of the divorced Muslim women or to those who have to get divorced from their husbands. The enactment of this act was done by the government of Rajiv Gandhi to invalidate the decision decree passed by the Supreme Court in Shah Bano Begum case. According to this act, Muslim divorced women should be entitled to adequate and reasonable amount of maintenance till the iddat period. When a divorced woman maintains a child born by her any time before or after the divorce, the husband is under legal obligation to provide a certain amount of maintenance for the child to a period of 2 years from the birth date of a child. The women are also authorized to obtain mahar or dower and receive back all the properties or estate which is provided to her by her parents, friends, relatives, husband, or husband's friends. If such advantages are not received by the divorced Muslim woman from her former husband, she can apply to magistrate for ordering him to provide her with maintenance or alimony or amount of meher or dower or her estate or property. As we see, the Shahbano case was a normal case just like any others of maintenance which have taken place before. The verdict that was concluded by the Supreme Court was also similar to the previous lawsuits as well, but the two naked truths that were witnessed in this case made this case a landmark judgment case. And the two naked truths were first, spirituality of religious personal laws was criticized, and then it was questioned whether uniform civil code is applicable to all religions and their followers, and secondly, whether the CRPC is applied to personal religious laws. This lawsuit was a milestone in judiciary as it was courageous, bold, impartial, and a unique decision. Thank you.